Hello, Salad Robinson here. This video is actually going to be somewhat different than my other videos. I normally my videos have to do with music, whether it's my music or someone else's music news, just talking about music, whatever the case may be. But and if you normally like metal music, that sort of thing, I invite you to actually subscribe to my channel. I put up do acoustic stream renditions of heavy metal, hard rock, heavy metal songs, pretty often, as well as I'm working on a 4-song EP that I'll be giving out for free next couple months as soon as I'm finished with it. But this video is actually nothing to do with that whatsoever. This video actually has to do with what I do for a living, which is I'm actually in the securities business. Now, securities, I'm not talking about, armed security or, being a security guard or anything like that. I'm talking about financial securities. First of all, what I want to kind of cover a disclaimer real quick. First of all, I'm not going to mention what company I work for, mainly because this video wasn't meant to be a type of advertisement for the company, which is actually goes into a bunch of other legal mumbo jumbo and all that sort of stuff I don't want to get into. Second of all, I want to say up front that I am not a licensed broker. I'm working at it. I'm studying for it still, but technically right now I'm not a licensed broker. I will not be. This video isn't intended to solicit any type of business, and or isn't meant to sway people into buying a particular stock, or trying to recommend any kind of stocks, make any kind of recommendations whatsoever. I'm not trying to do that whatsoever. So it's just I wanted to get that out there, just purely for informational purposes only. Okay. Now that got that out of the way, let me get to the meat and potatoes of my video. This video has to do with penny stocks. Now, the company I work for, we help clients deposit penny stocks, ultimately usually to liquidate them, to sell them. They want to sell them. People that they get involved into like a private placement of a company that is about to go public, whatever the case would be, or maybe it already is public, but they're doing additional private placements after that sort of thing. Some people for small startup companies, sometimes they have to when they bring on certain employees, or they bring on lawyers or accountants or that sort of thing. A lot of times they can't pay these people in cash, so they pay them in stock. And usually because they're just a budding company, usually their stock is a penny stock if it's under $4 a share. Okay, so there's a wide variety of reasons why people get stock. Sometimes it could be a debt conversion. You loaned the company a certain amount of money a while back, and they haven't been able to pay you back the loan with the interest, so you agreed to turn it into a convertible note, which ultimately meant that you eventually were converted into stock. Maybe that's how you got it. So there's a wide variety of reasons that you could possibly find yourself having a penny stock, a stock certificate, physical stock certificate. And eventually you're going to find, if you're that person, that boat, more than likely you're going to be needing a place to ultimately deposit it. Okay. Now, again, I'm not trying to solicit a company for you to actually deposit it. What this video is meant to do is to make sure, because make sure you understand the requirements that you're going to need to fulfill, both yourself and the company, before you're going to be able to deposit your stock. Okay. There's so many instances where we see clients that come in and they have stock they deposit, and they don't know the first thing of what they're going to need to give to us, what they should have kept from the purchase of the stock, if it was a subscription agreement, what other paperwork they should have kept from, if it was a settlement, or again, if it was a debt conversion, you need to keep the paperwork from the original debt, all that sort of thing, because that's all going to be needed when it comes to depositing your stock. Okay. I have my company's website up here right now. Just kind of going over one of their pages that actually talks about a lot of times what you'll need in a process. One of the things you're going to need is an attorney opinion letter. Usually, you first of all, you have to understand that the attorney can't be an affiliate from the company. That the issuer, the issuer of the company, nor if you are a lawyer with penny stocks, you can't write your own opinion letter. I'll just flat out tell you that you can't. It has to be a totally neutral third party lawyer that has to write this opinion letter. Okay, so as long as you understand that. Now, a lot of times, probably 95% of all the opinion letters I've ever seen come through our company, they always say that basically this stock qualifies for what's called Rule 144 exemption. What that is simply if the stock isn't registered, there are certain exemptions to registration so that you can still deposit it even though it's not registered. Okay, and one of those exemptions is called Rule 144. And there are certain requirements that are required for you to be able to that need to be fulfilled for you to be able to use and take advantage of that exemption. Okay, now the thing is, what you have to understand is attorneys will jump on this Rule 144 all the time. They'll look at any company and they'll say it's 144. 9 times out of 10, not even doing really any kind of investigation whatsoever. In fact, most opinion letters, they tell you they didn't investigate on their own. All the information was given to them by either the issuer or the client. And given that information, then we've deemed that this stock qualifies, and it's ridiculous. I don't know why they do that, but they do. Now, that being the case, what requirements of Rule 144 are this. First of all, you have to held the stock for at least six months if you're a non-affiliate, for 1 year if you are an affiliate. Okay. Now, once that requirement is filled, the issuer cannot be a shell, cannot have been a shell for a full year, and cannot be a shell at the time that you're trying to deposit the stock. And one of those ways that it's used to determine whether or not it's a shell is whether or not it's fully reporting. If you're about to invest in a penny stock that, and you're right at that point where you're about to dish out the money for that private placement, whatever the case may be, you want to find out if they're fully reporting. And you would find that out if you actually did some investigation of your stock that you're going to invest in. If they're not fully reporting to the SEC, they're not going to be able to qualify for Rule 144. If they haven't submitted anything after their S1, and they say they send all the rest of their filings to OTC markets, sure, they're up to date and and it's something to look at for investment purposes. But as far as qualifying for Rule 144 exemption to deposit your stock, you will not qualify. That issuer will not qualify unless it is fully reporting to the SEC and current, and has been current for a full year, and it has to be current at the time you're depositing your stock. Okay, so if that isn't the case, then question whether or not you want to invest in that stock, because it's going to be a little bit harder. You have to wait longer to be able to deposit it. It's not going to be impossible, but you have to wait longer. As long as it's fully reporting, at least with OTCs, then you have to wait like over 2 years to be able to deposit and liquidate that stock. If it's reporting with SEC, 6 months to a year, depending on if you're affiliate or not. Well, this is actually a big thing too. As soon as you get the certificate, a lot of times you'll have the tendency to want to sign the certificate in the back. Okay, we recommend that you do not. We, as in the company we work for, tells all of our clients, do not sign, do not touch, do not write in any way, shape, or form on the certificate at all. Okay, reason being is that the signature has to be exactly the way, and has to contain the exact wording, the exact name of the person of the account that is being deposited into. And if it's off by a middle initial, if it's off by a maiden name as opposed to a married name, and all that sort of thing, you have to get that. You have to get that stock reissued, from the transfer agent, and it's going to cost more money, and it's just a load of time and trouble. Okay, what we recommend is what's called stock power, notarized stock power. Okay. Sign that, and you submit that with your cert to whatever company you're going to be submitting your stuff to. Because thing is, if you make a mistake on a stock power, crumple it away, get a new stock power, sign that one correctly. You can do that. As long as you don't touch the stock itself, certificate itself, then you're fine. Okay. anywhere you go, you're going to always have to answer a bunch of questions on how you got the stock. Okay, they're always going to ask you about, again, was it a subscription agreement? Did you actually pay money for the stock? Was it a debt conversion? Did you work for the company and they paid you in shares? Whatever the situation is, you're going to have to prove that. Okay, now, I want to start off with subscription agreements. You actually paid money to get the stock. Okay, I'm going to tell you right now, cash is no good. Do not pay in cash. I don't know why people pay in cash, because when it comes down to proving what's called evidence of consideration meaning the money paid for the stock, okay, you have to be able to prove that you paid for the stock. You can't any clearing firm that's worth their salt and cares about being in this industry long term isn't going to just take your word for it that you pay that you paid for the stock. They're not going to take the issuer's word. The issuer saying that yes, this client or this shareholder paid all consideration necessary, has met every requirement to own the stock. They're not going to take that. Okay. Do you know the only people that financial institutions trust are other financial institutions? Okay. Now, obviously, first and foremost, it's best to pay with a check. Okay, checks are paper trails. Okay, now everyone thinks paper trails are bad, but in securities and depositing physical stocks, paper trails are good because it shows where the money went. It came from my account, went into their account. That's how they got the money. That's all you got to do. Show a clear check, that's stamped on the back, by the bank saying that we accepted this check. Money was good. The money deposited in the other account. You're good to go. Okay, wire transfers are good because your wire transfer has to move from one bank account to another bank account. So if the transfer happened, that means it went in from one bank account to another. Both sides can show that the money went somewhere. Okay, that's good. Now, if you're going to deal in cash and paying for your penny stock, okay, if you want to stand a chance in doing that, you need to put the money through your bank account first. There was this one client that we had one time who, when it came down, we got everything situated to go, and when they didn't submit how they got the stock as far as, they said they paid cash. Okay, well, we need, statements or whatever the case would be. It's like, well, we didn't actually, the money actually didn't come out of an actual account. She just had it stocked under her, one of those proverbial stocked money under her mattress, and she took that money and paid that money to purchase the stock. And I'm like, fool, okay? That money, you should have taken that money. If that was the situation, you should have taken that money, should have deposited into your bank account, take it back out of your bank account, and then paid them the cash. Okay? And then on top of that, but this is going to be the pain, okay? And on top of that, once you pay them their money, you need to be on their butt about getting a statement from them, of their bank statement from their bank, showing that the money was deposited into their account. Because unless you can't provide your own bank statement showing the money came out of your account and show a bank statement of theirs saying that the money went into their account, you're not going to be able to deposit your stock because you didn't show evidence of consideration that you paid for the stock and it went to the issuer. Or say in a situation where you bought the stock it was like a private transaction, you bought the stock from someone else who bought the stock from the issuer. Okay, you have to tack your purchase of their stock all the way back to the issuer, which means you need to prove that the money that came from you went to him, and then also the money went from him went to the issuer. Okay, so obviously private transactions are a little more hairy; they can be done, but again, you need to be prepared to be able to get that stuff. So if you're buying stock from a private person, private transaction, don't pay out money for that stock unless the paperwork that you're going to get from them is they're tacking back to the issuer, their subscription agreement from the issuer. Okay, whether it's on the S1 or whatever the case may be, you need to make sure that you have that, because you're not going to be able to deposit that cert unless you have that. Now, a situation where you work for the company, okay, you need, obviously you're going to have to make sure you have some kind of a consulting agreement that, in place, that obviously you're going to do some work, you did some work for them, that sort of thing. Then obviously the company will have to issue the shares you through some sort of company board meeting, that they're going to issue, like a corporate resolution, and they're going to issue the shares through the resolution, that sort of thing. That sort of thing. Usually that's not that hard to show. But like I said, you just want to make sure I have all your stuff in line as far as that. If don't say that you're giving accounting, consulting, and you're not an accountant, or law consulting and you're not a lawyer. Okay, don't try to do that, because that will be caught, and that's fraud. So don't do that. Debt conversion. A lot of times people, like I said, people will have debt, and the company will owe them for the debt that, they let the issuer borrow the money. The issuer can't pay them back, so what the issuer does, though, issue a convertible note, which once the company actually goes public, then at that point they can convert those shares, they convert that note to shares. What's good about that is, at the time of, I believe, the issuance of the note, for sure, you can tack that back. So the holding period actually starts at the beginning of the convertible note. Okay. I might be off on this, and I don't think it actually goes back to the actual debt itself, the very beginning of the debt, but at least goes to the actual issuing of the note, possibly. Don't correct me on that. I'm not too sure on that, but, worst case scenario, at least, the issuance of the convertible note, from that point on, your holding period starts. And, like I said, it really helps if the company is fully reporting to the SEC. Then you have no problems qualifying for Rule 144. If you're not an affiliate, you can deposit your stock after 6 months, and then you're good to go. A situation we're dealing with right now, where a client, so what happened is he owned a company, and what he did is he was selling the company to another company. Okay, and company A is going to sell itself to company B. Okay, company B said, we will pay you for your company in our own stock. Okay, and so obviously company A said, hey, that's great. And they looked, and stock's worth X amount, and blah blah blah. Things look great. And now comes the point where this guy, has the stock. He wants to try to he wants to try to sell the stock now, because ultimately he wants the money for his company. Now what's happening is, because what happened, I guess it was like a settlement agreement, obviously, with the transaction of the money and paying for the company, blah, blah, blah. Well, obviously, one of the things we're going to need is, because obviously that settlement is actually the consideration. The transaction of buying the company and getting the shares for purchasing that company, that's the consideration. Okay? We're going to need, the company, any firm is going to need the settlement agreement. Okay, in addition to all the other things they're going to need, that settlement agreement. Okay, now thing is, though, what's happening is now all of a sudden, the company doesn't want to. First of all, I don't know why this guy who sold the company doesn't have a copy of the settlement agreement. I don't know why, but he doesn't, and they don't want to give him the copy of the settlement agreement, because supposedly it's confidential. He doesn't want them. They don't want him giving it to us or to our clearing firm or whatever the case may be, because it's confidential information, blah, 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 blah. Okay. So basically, I don't know, is this guy getting, getting smoke blown up his butt? I don't know. Okay. But right now, as it stands, he can't sell his stock because the company, the issuer, won't cooperate to help him liquidate his shares. Okay. Now, so I'll tell you up front, like I said, if you're in a situation and someone starts talking about confidential subscription agreements or confidential settlement agreements or whatever the case would be, confidential, blah, 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 I would not recommend, I'll make this recommendation. I would recommend not to get involved in that whatsoever. Because if they're going to withhold information from you that you can't use in the depositing of your stock, you're sunk. Okay. This situation hasn't been closed yet. We're still kind of working on other avenues to try to get this information It's, you know, kind of crazy, but ultimately, it's one thing you want to consider as well. If there's anything, you know, confidential, some, you know, some information that they're not going to be willing or willing to disclose for the purpose of you being able to deposit your stock, it's going to be a hassle, and you're not going to be able to do it. Another thing too that, you know, I want to at least touch on is just a simple fact that you may also have to fill out what's called it's called a seller's representation letter. Okay. This is simply, a lot of times it's called a Rule 144 seller's representation letter. Okay. But chances are, any firm that you want to deposit your stock into is going to probably want that seller's representation letter, because basically what it tells them is, okay, say we do, if and when we do deposit your stock, are we going to treat you as an affiliate, or are we going to treat you as a non-affiliate? And you basically declare right then and there if you're a non-affiliate or if you're affiliate. And obviously you're going to be held to that answer for the entire time you're trying to liquidate that stock. Okay. It's the company basically officially asking you, are you an affiliate? Because if you are, then you have selling restrictions, and you have to, you know, wait longer, or you may not even qualify to deposit your stock, that sort of thing. You may have to wait longer, like I said, 1 year if you're an affiliate, or you declaring that you're not affiliate, which means you can sell right away, only hold it for 6 months. You usually don't have selling restrictions unless, of course, the stock's liquid. You know, then, you know, that's a whole other ball of wax. But you know, and that's their way of determining, okay, you're declaring to us right now that you are not an affiliate. So if we find out at any point in time in the future that you are an affiliate and you basically lied to us, your butt's in the fire. Okay, so that's basically them legally, technically wanting you to declare whether or not you're an affiliate or not. Okay, it doesn't have a whole lot to do with Rule 144, even though they're usually it has, you know, it's kind of intertwined in there a little bit. So even if you're not trying to use Rule 144 as an exemption for depositing your stock, say you're using, you know, Section 4, something like that, it's definitely, you probably are still going to have to fill that out. So, you know, go ahead and fill that out. Have it on standby just in case. You know, just get ready to send it in wherever you're dealing with. Just to cover mainly, just kind of wrap this whole thing up. Just to kind of wrap this whole video up. Like I said, a lot of the emphasis I wanted to point out was basically the whole proving evidence of consideration, proving how you paid for the stock, if in fact you paid for the stock, because that's going to be a big issue as far as depositing your stock. Okay, I mean that's ultimately what it comes down to. The SEC, FINRA have been cracking down on, you know, anti-money laundering rules and regulations, and making things more strict, and making things heightening the scrutiny of what, you know, firms have to do to make sure they're not, you know, participating or helping someone participate in money laundering, you know. So, and that's basically any company that wants to be in this industry, like I said, long term, will want all these to basically cover their own butt, so that, because what at the end of the day, what it comes down to is, if SEC comes in and says you illegally deposited this guy's stock, and, you know, asks how did you justify depositing that stock, and you can't show that you checked everything to make sure that, as far as you were concerned, that it was gotten legitimately and there's nothing wrong with it. Okay, if you can't show that to SEC, you know, you better prove that this person lied and basically falsified his documents. But you know that you asked for the documents, and the documents gave you the right answer. That's what they're proving. Okay, it's not because they don't trust you. It has nothing to do with that. It's because they want to be in this business long term, especially if they're dealing with penny stocks. They want to be in this business long term. You know how many firms that right nowadays are just dropping like flies as far as dealing with penny stocks. It's because they get burned too much. Because, you know, I guess they don't have the legal team to handle all the due diligence and investigation to make sure, you know, you're checking everything to make sure that, you know, these situations are legitimate. Because ultimately, at the end of the day, it's a true fact that there's a lot of shady things going on when it comes to penny stocks. Again, like I said, hope this video helps you out to make sure prepare you for being able to transact in the space of penny stocks and microcap stocks, physical certificate deposit, that sort of thing. And like I said, I mean, again, I don't want to actually tell you the name of my company, but if you do have any other further questions, message me. I'll try to, point you in the right direction, just to, as far as, whatever you may need. But like I said, it's just mainly, I just wanted to make sure you're informed. I've seen too many people not be able to deposit their stocks, usually because they just didn't know what information they needed to keep, what pay stubs they needed to keep, what checks they needed to keep, like the bill, got to furnish that at the end of the day. So, like I said, normally I do music videos, and if you're interested in hard rock, heavy metal, that sort of thing, go ahead and subscribe to my channel, and hopefully this video helped you if, in fact, you do travel in microcap stocks, that sort of thing. But anyways, this is Alan Robinson, and thanks very much.